Everyone, there's sandwiches in the back. Most of you found those, of course. Good. Hi, I'm Bob Shelby. I'm one of the judges here in the court, and I'd like to welcome all of you here on behalf of the court staff and the judges and our UACT team. We're extremely excited to have a chance to really, I think, officially roll out our UACT program. We ordinarily don't see so many people assembled all in one place here, usually only for our chili cook-off competition. So, no chili today. Let me just briefly explain what I think will happen today, and then we'll jump in. So I think I'll provide very briefly a general overview of the program and describe generally what it is. We'll have some comments from John Huber, our U.S. Attorney, who's with us here today. And then I'll jump into, spend some time in the mechanics of the program, trying to educate everyone about how the program works, and we'll do that in two steps. We'll talk about how do you get into this program, and then second, once you're in this program, what happens? And then I'll more formally introduce the members of our UACT team that are here today, and we'll have a chance to hear from all of them with their different perspectives. Hopefully we'll have some time at the end for some question and answer period. You may have questions. This is going to be new to all of us, and we'll all be learning as we go. Just briefly, first, an overview of the program. And before I explain what the program is, let me explain what the program is not. It is not this. It is not get out of jail free. Neither is it this. Oh, no. And then it didn't run for me, did it? It's always run before.
If you vote for me, how long you want this thing to come through?
Any excuse to place a Napoleon Dynamite at a court function. As a side note, most of you may know this already. Judge Alba, who was here for many years as a magistrate judge, was the inspiration for Pedro, the character in that film. That is a true story. Ask him to tell you about it sometime. This is not a program where everyone's wildest dreams are going to come true. It's not a get out of jail free program. It's a program that requires an awful lot of hard work from those few participants who are fortunate enough to be selected to be part of the program. This is a first of its kind post-plea diversion program here in Utah. It is modeled generally after programs that are running in a handful of other courts around the country, in California and in New York and a few other places. But it is unique to Utah, and we've designed it in a way that is unique to Utah. And we'll get into the details, as I said, in a few minutes. It's a program that will provide participants an opportunity to either earn a dismissal of the charges against them at the successful conclusion of the program, or in some instances, an opportunity to earn a non-custodial sentence, a probationary sentence. Interested defendants will compete for spots. There are a very limited number of spots that will be available in this program, especially to begin, and I anticipate, and the team anticipates, a large number of applicants. It's going to be hard to get into the program. Applicants will prepare, I'm just going to use some crude terminology today. I think it's the terminology our team will likely use. Applicants will prepare pitch letters and sell themselves to the committee and explain why they're good candidates for this program, why this program makes sense for them, why they make sense for the program. Selected participants then have an awful lot of work to do. So the folks that get accepted into the program will be required to comply with very strict conditions during the course of the program and on their release, including frequent drug testing. There will be weekly meetings in our court that the UACT team and myself will conduct. They'll be required to be here every week. Some of them will be selected and will be required to complete oral recognition training, or MRT, as some of you know it. There's a community service component to this. There is tailored and individualized treatment that we're going to order of participants. There will be court assignments, like homework. It'll be like going to school for some of these folks. We're going to require, in some instances, that people read chapters from books and prepare reports, to write essays, providing some insight, I hope, for the participants into some of their shortcomings and some of the things that they're going to have to do to improve and be successful. Ultimately, the participants will have to do just about anything our team can come up with, dream of, to ensure success in the program. And what is success? In my view, success in this program means that we will have changed lives in a significant and meaningful way. This program, I think different people have been confused about it. In my view, this program is designed to change the trajectory of the lives of the participants, to give them some skills and some education, some support, some confidence, and some meaningful ways to address the behavior that they engage in that is criminal, and find a different way so that we don't have recidivism. My objective is to empower these people to lead and make our communities and families safer and stronger. And I think that's what we hope to accomplish. The U.S. Attorney's Office, I'm going to speak a little bit out of turn because so much of this work, there have been so many people here at the court that have done so much work to get us here. And almost all of that was done long before I came on the scene. So I don't even know all the great details about all the great work that everyone did. But the origin of this program, as I understand it, is our U.S. Attorney's Office here, and that is remarkable. This program is only possible because John Huber and his office support it and are willing to give it a shot. And this program will only last as long as the U.S. Attorney's Office supports it, and as long as the program enjoys the support of the U.S. Attorney. And this is an important point. I want to spend just a moment on it. I don't want to make too much of it, but it's worth noting for sure. I think it seems to me that many, if not most, of the U.S. attorneys nationwide who have been presented with programs like this or ideas like this have resisted them or rejected them. And while pilot programs, maybe like this one, are becoming more common, there's still a very, very small number of them. And there are a number of reasons for this. One is many U.S. attorneys, I think, might correctly think about that prosecutorial discretion that they're exercising, or they're required to exercise. And it's a fair question. If the U.S. Attorney's Office has correctly and ably exercised that prosecutorial discretion, charged the right individuals with the right offenses in the first place, and what space is there for a program like this that unwinds that? There's another reason that I think a lot of prosecutors and U.S. attorneys are rightfully skeptical about these programs. I don't think it's well established at all yet whether they work. Judge Wells knows a lot more about this than I do, and Judge Pete also. I don't think there's tremendous data yet on whether programs like this really make a significant difference. Do they make our community safer? Do they make it less likely that we'll have recidivism from the participants in programs like this? John Huber doesn't know the answers to those questions, and neither do I, but he's going to find out, and so I'm grateful for that. I think, I won't speak for John will speak in a moment for himself, but I think that it's significant that our U.S. Attorney's Office is at least open to the idea, it seems to me, that once they've exercised that prosecutorial discretion, and all of us who are involved in our criminal justice system have our different views about how that responsibility is just discharged on a case-by-case basis. But I appreciate the idea that we're open to the notion that after that charging decision is made, after folks are here, we might learn more about them. And the United States Attorney's Office, in some instances, where appropriate, dismisses counts or charges or cases. And I think this program provides an opportunity where we might learn enough about individual defendants to conclude after that charging decision that maybe this is the right course to land at the right result. So we'll see about that. I do know that programs like this require an enormous amount of time and investment. Our team members do this on top of their full schedules. The court staff does this on top of our full calendar. It's a significant investment of time and energy and resources by the probation office, the prosecutors, the defenders, the court staff. And when I've talked to my colleagues around the country who are involved in programs like these, it's the same story. They just spend a ton of time, and they love it. And that's the best evidence in my mind that programs like this work. The judges who've been doing it in California for 6 years, and the folks that work in other courts that have done this, genuinely believe that they're changing outcomes and changing lives in a really positive way. So I'm excited about that. At the outset, I want to thank John Huber and his office for his support, Kathy Nestor, who's here also, and the support of her office, Dave Christensen, our probation officer. We have an interagency agreement. This was an agreement formed and supported by the court and by the U.S. Attorney's Office, the probation office, the defender's office. Everybody has gone all in. We're jumping in the deep end of the pool, and we're going to find out whether we can swim or not. So before I get into the details, let me invite John, if you'd like, take a moment and share your thoughts. Would you please?
So in 2013 or so, the Attorney General Eric Holder announced his Stop Crime Initiative. And us cynics and critics, of course, we find things to make fun of in that. Well, we've done on crime before. Kathy's nodding with some vigor. Well, I like to please my bosses. I do, and that's pretty much where this came from. Before I was appointed by President Obama to be the United States Attorney, I attended a seminar sponsored by the department, and the best practices of the country were put on show to U.S. Attorney offices throughout the country to see if there's anything that caught our attention. And I sat through a number of sessions. Some of them did not appeal to me. Some of them may have been originated and practiced on the planet Lectar, as far as I could understand. They didn't seem like they would fit in Utah. But then I saw a couple ideas that I thought could fit in Utah, and I thought that if I became the U.S. Attorney, that I would like to give those a try. And one of the first things I did right out of the chute was I talked to people in my office about this, and talked to Alicia Cook, and I said, Alicia, you're going to be in charge of this. You're going to take point. I'd like you to figure out what this idea is and if it has promise for Utah. So she organized a multi-agency field trip to Los Angeles, the Central District of California, where they had done this for some time, and I'd seen their presentation about this post-plea diversion, which is code for plea in advance, right? I mean, those of us who practice in state court, we do this all the time. But in federal court, unheard of. Not possible. Never going to be. That's true. Plea in advance will never happen, but a post-plea diversion. Now we're talking. So that's where this came from, and people got excited about it. The acronym, where does that come from? Alicia Cook. AUSA, Alicia Cook's mind. It's brilliant. And it's positive. And we're positive about it. We're optimistic about it. There's a three-legged stool upon which what we do in the U.S. Attorney's Office and the Department of Justice, upon which we sit. The three legs are enforcement, prevention, and reducing recidivism through reentry programs. And I'm a prosecutor. That's what I've been from the very beginning. A number of you have mentored me as a prosecutor, given me advice through those years. And I like to file cases. And I hope you've seen an uptick in the cases that we brought since I became U.S. Attorney a year ago. I like to file them. So the first leg of that stool will not go away. We can't send a kind note in the mail to a troubled soul inviting him to change his life and come to a meeting and meet friends. The note is called an indictment, and that's still how we will affect change in the community. We will still deliver those. Jim will deliver those on behalf of my office, and with a friendly smile, I'm sure. And that's what we'll still do. We're going to put a lot of effort into prevention. We're going to put a lot of effort into reentry. And as you know, there's a long tradition that predates me, predates a lot of these efforts. Judge Wells has been involved in a number of those. We've got good things going in Utah already. This is another version and another effort. And you have my commitment that while I'm the United States Attorney, this will be a priority for me. And I will continue to try things. I will be honest, though, and my team will be honest, just like we hope to be in our investigations and our prosecutions. We will follow the evidence where it goes. And if the evidence and these experiences tell us this is this is a loser, this is not doing anything, we're not going to put too much more effort into that. But if something blossoms and is successful and gives us hope and more optimism, we will pour more resources into it. I mean, look at who's over here. Look at the resources over here. I've got 3 AUSA folks that I've assigned to this particular project. And I hope that signifies something to you. So my message to you is that I'm sincere about this, at different levels, of course. I'm a prosecutor, I'm a U.S. attorney, very grateful for this opportunity, and I'm concerned about broader community issues, crime issues, public safety issues that are very difficult to confront and address and try to succeed at. Now we're going to deal with individuals, one by one, and the same dynamics will be there. They'll be puzzling. They'll be traumatic. It'll be very difficult to make progress with these individuals. So it's a micro scale for something that, if it works, we can maybe broaden to a more expansive community scale. So I'm optimistic, and we'll try things like this. We'll take a step in the dark and see how it goes. I'm very grateful to Judge Shelby and to Magistrate Judge Wells and the others, and Dave Christensen and others who have helped us, Kathy Nestor, who have helped us bring this into better focus to where we can kick this off today. It's been the better part of the last year that we have worked on. And we should take pride, like Judge Shelby said. We should take pride. We're like the Japanese. We take something and we make it better. So we're putting our stamp on this as Utah. And we do, we should pat ourselves on the back a little bit. In that in Utah, in the law enforcement community, we have good partnerships. We talk together well, especially compared to other districts or jurisdictions. And then I think we have something very special in the federal bar. And that's exhibited today by your interest and support in what we're talking about today. And I remember well, and I've told this story a couple times, but when I first came over to the U.S. Attorney's Office in West Valley City, where a number of you knew me, and we had cases together. And then my supervisor, Brooke Wells, walked me around the old courthouse and introduced me to as many people as she could. And she taught me a lesson about how this was different in the federal court, and things will feel different. And there's a certain collegiality amongst the bar and between the bench and the bar. And we have a role in trying to perpetuate that. If not maintaining, but maintaining at the very least, and enhancing, if we can, through our own practice. Here's another opportunity where we can team together in a new way, a collaborative way, still a little adversarial, I'm sure, but I think our federal bar and the tradition we have, we can do a good experiment here and see if we can succeed and help individuals succeed with the eye toward helping the community succeed and improve on this front. So thank you very much, Judge, for letting me speak.
Thank you, John. Appreciate those comments. One of the main takeaways that I just took from John's comments was that if this fails, it's Alicia Cook's fault. Probably right. Okay, so let's take a moment and talk about the meat and potatoes. This is what a lot of you are most interested in. How's this going to work? How do you get your clients into this program? How do you get defendants into the program? I'm going to periodically refer to the interagency agreement. It is on the website at the end of all this. I'll explain where you can find additional information and materials. But this is a flow chart we made. I realized a half an hour ago that there's one mistake on this. I've looked at it a dozen times. I kind of built it, and there's a mistake that I'll point out in a moment. But this is the funnel. This is how we'll bring folks into the program. So it all will happen at a selection committee application review. But to get there, defendants will be applying to the program. And any defendant is eligible to apply to the program, but it's not an easy application process. It's a lengthy application process. There's a lot of information that the defendant is required to prepare and assemble in a pitch letter. Defendants may make direct application. Their counsel can prepare an application and send it to my chambers. The applications for admission into the program should be sent to my chambers. It will be a repository for the applications. We'll hold them. And at least in the first instance, we don't have regularly scheduled meetings of the selection committee. We'll see if we get a regular and routine number of applications at a certain time and we're getting turnover in the program, we may schedule meetings regularly. In the meantime, they'll be ad hoc. They'll be as needed when we have openings in the program and when we have a sufficient number of applicants to review. This means if you're representing a defendant in a case and you think that your client makes a good candidate for this program, you may have some frustration because you don't know if and or when your application for this program will ever be considered. In the first instance, we're going to start with a small group of 8 to 12 participants, I think, in this program. That's my vision of it, and we'll see. This is flexible. The program runs for a year or 2 years, depending on which group the participants are in. I'll give more information about all this in a moment. Once we get to about 8 folks, there won't be a seat in this program for a while. So your job, it seems to me, is to continue to zealously advocate for your client in their case. And they'll stay in their case unless or until this committee takes some action on that application, as I'll explain in a moment. So, defense counsel, savvy defense counsel who find the right client they're representing in the right case, who thinks they're a good fit for this program, should discuss it with their client, talk about it, what's involved, prepare an application, and submit it to my chambers. We're mindful that a lot of other folks in the criminal justice system have contact with defendants, including the probation office, the defender's office, other judges here in the building, the magistrates, the district court judges who are involved in the cases. Mindful, again, about the correct role of all of those entities in our criminal justice system. A judge may see a defendant in a case and think, this seems like a good candidate for the program. They've been performing great on supervised release. The more I've learned about their background, they look like someone that might fit. They may make a referral. People are welcome to make referrals and suggestions. Those referrals or suggestions should be sent to my office in the first instance, preferably by email, but you can call also. The judges will just walk down and knock on the door, I know. But if you make a recommendation, if someone refers somebody to us for consideration of the program, I'll send a letter to their lawyer and just tell them, we've received a referral or a suggestion that your client might be suitable for the program. If you're interested, here's what you need to do to be considered. Then they'll prepare an application and they'll send it in to us. The requirements for the pitch letter are set forth on pages 3 and 4 of the interagency agreement, which you don't have. We didn't print off the interagency agreement. It's long and it's detailed. You need to read it if you're going to consider asking one of or inviting one of your clients into the program. So from time to time, when we have openings and we have enough applicants, we will convene a meeting of the UACT Selection Committee team. That's the UACT team minus me. I won't participate in the meetings or the selection, the vetting of applicants for the program. In my judgment, it is too near plea negotiations. That's an open session. It is actually completely closed. But I mean, there will be an open dialogue between these folks and hand-to-hand combat, getting involved, discussing and vetting the applicants that are in front of the committee. And this will be with the benefit of information and a report that we'll have from Greg Peterson, who in advance of these meetings will run reports that will provide us additional information about the criminal history, and he can tell you more about what he can learn about the applicants. It all gets assembled, the team meets, it's a black box meeting, and they go through the applications. And I have, the one thing I have shared with the committee is my view, though it is their decision, that there are the right applicants for the program, and those folks should, if everyone agrees, should come into the program. But we shouldn't be picking people just to fill seats. It's not a competition in a sense that 1 out of the 10 applicants before the committee on any given day will be selected. Maybe none will be. Maybe we'll have 3 empty seats. The most critical feature in my mind is finding the people who are most likely to succeed in the program. So these folks will meet in private, in a confidential meeting, to review the applications, and we'll make a decision about whether to invite anybody to participate. And that will only happen if there's unanimous agreement by the committee. The U.S. Attorney's Office, the Defender's Office, even probation, all hold a veto. If anybody disagrees for any reason of the defendant being accepted into the program, they won't be accepted. So, and if you're curious, you're representing somebody, you want to know, or is there going to be a meeting, when's the meeting going to happen, you're welcome to contact Mary Jane in our chambers, and she'll just keep you advised if a meeting gets set. But in any event, 2 things will happen at that meeting. Either folks will be rejected, applications will be rejected or received. If applications are rejected, they drop down here in the rejection pile. This is where there's something that is a misnomer. There's an arrow from rejection to the defendant being transferred back to the original assigned judge. That's misleading. The applicant stays with the assigned judge in the assigned case the whole time, unless or until there's a preliminary acceptance by the committee. So we've received some orders, some draft orders by defense counsel asking us to stay, or some judges have received application or orders, motions to stay criminal proceedings so that a defendant in a case before them can be considered by the UACT team, and that's fine. I mean, that'll be between counsel and your judge about whether in any given instance it makes sense to stay a proceeding or stay a proceeding as to a defendant to allow this to run its course. And I don't know how that's going to work. We'll see what judges think about it and how they deal with it. It seems to me that cases are moving on until they're not. But in any event, so if there's unanimous agreement by the selection committee that somebody should come into the UACT program, then the judges here have authorized me to automatically enter an order in those cases where the defendant is moving forward. So even if it's not my case, if it's Judge Kimball's case, I'll enter an order, I'll notify Judge Kimball that the defendant has been preliminarily accepted into the program. I'll enter an order that will automatically stay speedy trial time, and I'll grab the defendant and pull him out of Judge Kimball's case, and he'll be reassigned to me. I mean, he'll still be in the same indictment, but I'll be his presiding judge now until we get to the end of this flow chart. That preliminary acceptance is just only that. That's a preliminary acceptance. There's a great deal more that still has to be done. Once I enter that order, transferring the defendant to me and staying time, then we'll set a status conference. We'll bring everybody in for a status conference, and at that status conference, we'll set a change of plea date. We'll order the preparation of a pre-sentence report, and we'll go about 60 days. So about 60 days from the date of that status conference will be our change of plea. In the meantime, something unusual is going to happen. It is a requirement for participation in this program that the defendant, through his or her counsel, and the U.S. Attorney's Office reach agreement on an 11C1C plea agreement. Everybody will agree before the defendant is accepted into the program what the result will be if the defendant fails or if the defendant succeeds. And I skipped one part. Part of the preliminary acceptance decision by the selection committee will be a determination about whether any particular defendant is most suitable for what we call Group 1 or Group 2. Group 1 participants are people who at the end of the conclusion of the successful conclusion of their participation for 12 months are eligible to have a case dismissed. Group 2 participants, it's a 2-year program, and they're eligible to have a probation-only sentence. But in both cases, defendants, through their counsel, will have to successfully negotiate an 11C1C agreement, and it will specify you're in Group 1, you're in Group 2. You succeed, your case is dismissed for probation. You fail, this is the sentence. And that's set at the beginning. If there's a failure to reach agreement on the 11C1C, then the defendant drops back out, and I reassign the person back to the presiding judge in the first instance, and on you go with your case. This is going to require a good faith effort by everybody to make it work, though it does work in other courts that do this. Assuming defense counsel in the United States reach agreement on 11C1C plea, Then you show up for the change of plea hearing, and then the question is whether I'm willing to accept the plea. I have a hard time imagining the circumstances in which I wouldn't, though who knows? If everybody else has reached agreement, there's an 11C1C, the committee has vetted it, this looks like a good participant, then I accept the plea. The defendant signs a contract. There are contracts for participation in this program. They're available on the websites we'll be talking about in a moment. We sign the contract, I accept the plea, Bob's your uncle, you're in the program. If I reject the plea, you go back to the underlying case. So at that point then, we have participants in the program. That's the process to get through the funnel and get into the program. So what happens once you're in the program? So the interagency agreement describes what happens in the program. It's long. And I'm not going to spend a great deal of time on it here because, candidly, it's going to evolve, I think, as we all learn about what works and what doesn't work and what's most effective. The short answer is there are benchmarks that are set forth that the court, the U.S. Attorney's Office, the defenders, probation, we've all agreed on. There are 5 phases generally set forth in the interagency agreement that describe sort of the initial orientation. This is when we identify the treaters, the treatment providers, the kind of counseling or treatment that's going to be most beneficial for this defendant. We start with the frequent drug testing. We have benchmarks for periods of sobriety, etc. And at each successive stage, we move from sort of a journey for our participants. And we are going to successfully move them through 5 phases in the program. And some people are going to skin their knee, fall down and bleed a little bit, and we have outlined in the interagency agreement broad discretionary sanctions that will be available to us as a committee. The defendants who participate in the program agree to be subject to these. So subject to input from the committee, I'll be making decisions from time to time as necessary to figure out what to do with somebody who doesn't seem to be staying on the trail. And the idea is progressive sanctions and start softly and gently and bring them along. And of course, this wants to be a supporting and loving environment, and every now and then it's going to be a little adversarial. There's discussion in the papers here about what to do when we get to that point. Under what circumstances a defendant in this program will be entitled to an adversarial hearing, and what the defendants can challenge and what they can't challenge as part of the program. I missed another part to all of this. That is, when the judicial officer accepts the plea, the federal defender's office is assigned as counsel in the case. That will be true for almost everybody, but not everybody. There will be an exception we'll talk about in a moment. And we have 2 fine representatives from the federal defender's office on the committee. They'll be present. They'll be looking out for the defendants. They become the new counsel. So if there's CJRA counsel, for example, that representation is terminated after the plea is accepted. The federal defender's office becomes the new counsel for the defendant. There's a complication that we're just going to have to work through for defendants who don't qualify in the first instance for appointed counsel, who are represented privately, who get this far, and we'll just figure that out as we go. But we're not going to have 30 lawyers or 15 lawyers sitting in our meetings, so we'll see. We'll figure it out. That's the gist of it. Love, encouragement, support, and a lot of work. We're going to press these people. There will be a premium on honesty and being forthright and candid with themselves and with us and with each other. One of the things that courts have observed in implementing these programs in other states is that there's a great synergy that happens, and this is true especially with the diversity in the population in the program. And it's something I want to thank John Huber for being open-minded and willing to take a shot at this. This is a little bit risky, but it seems really helpful to have participants in the program with different experiences, different life experiences. Some of them will have had not insignificant criminal history. And one thing I observed in California, and the judges there talked about a lot, was the value of having somebody who's 61 years old, who's had several runs through the door here in federal court, and for whatever reason, they're at the right place in their life, the right time, with the right support, that everybody believes they are ready for a change. That person has an interesting story to share with the 19-year-old next to them who's indicted for the first time in federal court for drug distribution, about the course on which that person's headed. And it's interesting. There will be programming as part of the process. We'll be bringing in people who can educate our participants about whether it's work, skills, how to prepare a resume, how to interview for a job to try to help these folks land good employment. We'll talk about health and exercise. Well, obviously, there will be drug counseling and mental health counseling for people that need that. Basic training about how do you open a checking account, financial responsibility. Whatever it is, we're going to try to design tools and presentations that will be suited to the folks that are seated there with us in the courtroom. That's the substance of the program. At least that's my vision for it. So that's a short version. Read the interagency agreement. It's not the most exciting read, but it is informative and detailed. Let me now take a minute and introduce the team and invite them to share their thoughts or perspectives, if any, that they'd like. So we have two representatives, both from the U.S. Attorney's Office and the Federal Defender's Office. Stu Walls is here along with Jennifer Goley. From the Federal Defender's Office, you all know Lynn Donaldson and Natalie Benson. Alicia Cook is also here. I didn't mean to jump over Alicia, but she's going on special assignment, and so she won't be with us for very much longer. Greg Peterson from the Probation Office, and Judge Peede refused to sit up here with the rest of us. I don't know why, but Judge Peede, who already manages our tribal reentry court, has agreed graciously to help me with UACT as well as our assigned magistrate. So he'll be involved for sure from time to time, and sometimes we'll sit in on the meetings when I can't be present, and are available to impose sanctions if I'm not around at the time. Let me just a word about sanctions. Read the part about sanctions. We don't want folks to get this far in the program, but there may be times when we will have flash incarceration. I mean, if we get far enough along and we're having problems and we can't manage, we need to send a signal. There may be a warrant that just issues on a Thursday or a Tuesday or a Sunday or whatever. So more information, of course, in the interagency agreement. Let me invite all of you to share any thoughts or comments you have, Stu or Jennifer. And there's a microphone up here if anybody will cares to speak or undertake.
Can everyone hear me? Yes. Can everyone see me? How's that? Can you still hear me? Okay. Well, this has been a long time coming. When did we go to California? Was it early 2015 or I can't even remember. But this idea came from John Huber, and I just want to thank him because I'm really excited about this program, and I can't wait to see what comes of it and the good work that everyone here will be doing. But John first brought it up with the reentry subcommittee, and so I want to thank them, thank Judge Wells and Megan and Michael and Spencer Rice for all being willing to go out to California and look at this program and help me come up with the ideas to get it started. And Judge Peede was also very involved in the process, and every single judge in this building sat down and met with John Huber and I and gave us their input and their ideas. So many different people have contributed to this, and it has taken a lot of time to get to this point where it's about to start. And my hope for this, in addition to rising to the challenge issued by the Department of Justice to think about crime in different ways and maybe approach it in some more intelligent, more innovative ways, my hope is that we do reduce recidivism. The people that come into this program, it will be a victory in my eyes if we don't see them back in the criminal justice system. And we do have a lot of great programs that are geared towards the end of the process when people have been sentenced, they're on supervised release, and they violate and they come into our reentry courts. This is an effort to try and address and get involved at the beginning of the process and see, is it possible to use the criminal justice system to create positive change in the life of somebody who may be struggling with different issues. So thank you all for coming and attending and learning about this program. I hope you will remember it, think about it as you come across different cases and different defendants, and you find those unique individuals that seem to have something about them that just makes you want to try and give them an opportunity like this. And
this will amaze those of you who know me, but I don't have much to say. Actually, I think a friend of mine once said, this is a pretty sad life, there's no redemption. And I think redemption is one aspect of the criminal process that has been lacking in some degree. And so my participation is, one, because the boss asked me to do it, and two, because I hope, like Alicia said, that there can be redemption for people who learn.
I don't have much to add to that. I'm Jennifer Goulet. But I did want to say that I work a lot with Natalie and Greg and others in the reentry course, which is at the final end that Alicia referenced. And we're trying at that point to do a last-minute intervention to see if we can make some changes in someone's life. And prosecution generally represents a moment of intervention in someone's life at the front end. Most of our resources, as U.S. Attorney here said, go into removing them from society for a period of time, putting them in prison, hoping to give them some time to think about the choices they've made and maybe some different choices they want to make when they come out. Most of them come out wanting to make different choices, wanting to have a different life. Most of them are not always successful at that, hence the problem with recidivism. So I think the beauty of this program is in taking that prosecution moment, the intervention moment at the front end, and helping keep people engaged in pro-social behaviors, whether it's education, trying to get better at employment training, and for many of them, getting them the treatment they need for mental health issues and addiction issues, with the idea that if we're able to kind of shore them up with those life skills, as it were, that maybe the life of crime and making poor choices won't be as effective to them.
I'm Greg. You guys hear me okay? Greg Peterson with U.S. Probation. I think it's just finally awesome that this is finally here. It's been a long-awaited program to have diversion, plea in abeyance, Jones guns, I can say it, in the federal system. I know our office is committed to giving them the supervision and the resources and the time and energy that they need, so just happy to be part of the team.
I'll just say a couple things real short. 27 years ago, in front of Tom Green, I tried a case where my client didn't make a penny in fraud. He used a phone, worked in a boiler room. He's going to have a felony conviction for the rest of his life. 19. Absent presidential pardon. So I see this, he wasn't this. At least the jury found he wasn't on one count. But I see this as a way to give people a chance for a better life and to deal with the root causes of what really affects a lot of our clients. So I like the fact that we're working towards real change.
Well, I'll just reiterate what my colleagues have said, but yeah, realistically, the minute a person goes to prison, the odds of their ever becoming a productive member of society drop significantly, especially if they're looking at a federal sentence. So I view this court as a tool where we can maybe turn that around for people who show potential of actually benefiting society instead of being drained. I'm really excited about it.
All right. Thanks to all of you. So we have put together a website. It's live now. You can find it in several places. There's a short description of the program. We've got some links to a program overview that I think you have with you in your materials. On the flow chart you just saw, the interagency agreements available there, as well as copies of the contracts that participants will be required to execute when they enter the program, and the speedy trial waiver. The speedy trial waiver, this in case there's any confusion, the speedy trial waiver is signed by you and your client at the time that you prepare the application and submit it. It only comes into effect in the event that there's the preliminary acceptance, at which time that speedy trial waiver that you've already prepared is attached to the order that I enter, and it provides part of the basis for the speedy trial stay, or the stay of time under the Speedy Trial Act. So this is available on the intranet, the court intranet site, for those of you who access that. The court's internet website has it. It's on the front page of both of those websites. Also, on the district court internet website, if you go to judges and you select me, there's a link to UACT on my website. And there's also one on the court's reentry court website also. Thank you, Judge Wells. Let me share with you 2 little dates that you want to keep in mind, and then open the floor to questions and answers. So we've received a number of applications already for the program, and I've already scheduled a date. The review committee will meet for our first, I'm just going to crudely call it a vetting session, on September 15th. Any of you who have clients you're thinking of right now that you think would be good candidates for this program and you wish to have considered in the first instance, you should have any applications you'd like for us to consider at that meeting on the 15th to my chambers no later than Thursday the 9th, 1 week before. Any applications received by Thursday the 9th will be part of the packet that will be prepared and provided to the team for review and consideration on the 15th, and I anticipate preliminary decisions will follow that same day. All right, so there must be questions, or maybe there won't be, but any questions? Yes? Convictions. Oh, I don't have any idea about that. Congress would have to do. Kathy? The question was whether this is some indication that expungement is a possibility at some point in the future.
I would have mentioned about restrictions on the nature of offense.
Oh, so I will do that. So the answer to your question is Congress. Such as that's the answer to any question. All right, no restriction on offense. So I do want to address this for 2 reasons. One is this isn't how the program was initially proposed, so some of you may have heard about this program in an earlier iteration. As it was initially contemplated, this program was going to begin only with one type of offender and one type of case. It was going to be identity theft cases, which do seem well suited for this program in many respects. But for a number of reasons, Judge Pete and I proposed, and John Huber agreed, and the team agreed, and the court agreed. That didn't really make great sense to us. We want diversity, as I said, in the population in the program, and also there are well-suited candidates who are accused of other crimes, and John agreed we just jump in the pool and try. So there is no restriction, there is no limitation. Obviously, think twice before you prepare an application for someone accused of a triple homicide, some child sex offenses and the like, but look for the right person at the right place in their life where this program could be impactful. Questions or comments? Another question. All right. Okay, 2 good questions for those of you who couldn't hear. And I meant to talk about one of these earlier. As part of that review process, when the selection committee meets to review the applications, none of the information presented or discussed at that meeting will be available to any person. It is absolutely a confidential, sealed meeting. So that it can be a candid and frank and open discussion. There will not be an explanation provided or forthcoming. In fact, the committee members are prohibited from providing any information to any of you about why your client was or wasn't accepted. It's a yes or a no. And then the second part of the question was, is there an appeal process? There is not. This program, I meant to say these words earlier while John was here. This isn't a program of right. It's a program, I don't want to say a program of privilege. It's one that we're all very excited about. But there's no right to this program. There's no right to participation. It's an opportunity for the right people. So no appeal, unfortunately, and no explanation. Hopefully good results. Hi.
When you talk about like the right fit, you mentioned the right person at the right time. So do you think that the business of the defendant themselves or more the types of crimes that they have committed or convicted of?
So I don't know if, I'm going to invite the committee members to talk about this if they wish. I think we all have a lot of learning to do. The committee hasn't yet met to evaluate applications. We did talk about what we wanted to know from applicants, and we talked about, this is set forth in pages 3 and 4 of the interagency agreement. We want to know Tell us what case you're in. Provide an explanation of the criminal conduct that's alleged in the case, including the applicant's alleged role. Tell us about their criminal background, their personal history, their prior criminal history, anything that they've done to try to address on their own. Triggering events for criminal conduct, whether it's substance abuse or addiction problems or mental health issues. Tell us how they've done on probation or supervised release. Tell us what other mitigating or aggravating factors might be there and the like. I'll be curious to see how it evolves. And my impression of it is that at some level it's a gut check, but the more information you can provide, the better. There's not a firm set of criteria. This was part of the question you posed also. It's not a checklist. I think there's going to be some instinct involved. Does anybody want to add anything to that? We'll have more information. We'll do this again at some point, maybe in a year or two, and we can talk about how the program is developed and what we're doing, how people seem to have done, what we've learned about how we have narrowed in on the types of traits and characteristics that seem to be most successful. But at the outset, I think we're just going to do the best we can. Anything to add? Anybody? Yes?
Just, is there more chance that
Okay. That's another great question. The question for those of you who couldn't hear is, so what happens if, as part of this program, either in the application or in the program, a participant's revealing information, is there any guarantee that that information won't be used in a criminal proceeding against the defendant? This is an obvious concern, especially where I can't stress enough. I hope all of you will stress with your clients that you're thinking about recommending this program. We will stress it constantly with our participants. The absolutely essential commitment to being honest and forthcoming. If we're going to make any progress in this program, that's the starting point. And so there are some protections in place. The interagency agreement sets forth restrictions on the use of information as disclosed in connection with the program. So you can't immunize yourself by being in the program and say, blurt out in the middle of the meeting, in 1978 I killed a man in Wendover. We've all heard that before. So you can't immunize yourself. But if you're in the course of discussion, and we're all sensitive about this, we have defense counsel that are involved in the program, and sensitive and careful prosecutors, and I'll be present of Judge Pete. We want to be careful about this, but we want to learn about what it is that we need to change. If someone's acting in good faith and providing information here, there's a guarantee that it won't be used, except under certain circumstances. And one thing the United States Attorney's Office agreed to, and it's in the program now, is that if the United States Attorney's Office thinks something was disclosed that either has to be reported or that they have to take some action on, they will notify the participant, and that information still cannot be used until I've considered it, and the participants had an opportunity to be heard with their counsel, and I've made a decision. And the U.S. Attorney's Office has agreed that they would abide by an independent third-party decision. So if I say that it's information that can't be used, then it won't be. But if it is, for reasons, because it doesn't appear that the disclosure was advancing the purpose of the program, it wasn't related to the program, it wasn't something that had to be, anybody called for, whatever, then that kind of information might be used. But we're going to be careful. We'll figure that out as best we can. Yes, Rebecca.
It sounds like a speedy trial act clock between picking until the person is narrowly accepted. Has there been any discussion about whether or not waiting for that decision is grounds under the speedy trial act or emergency case?
I don't know the answer. We thought about that. I thought about preparing a draft order that the other judges could consider if they wanted, if there was somebody in front of them that they knew was applying and the judge thought it seemed reasonable under the circumstances to enter the order. I ran out of time and didn't do it, and then also thought that's not really my place. The other judges it'll be a judge by judge, case by case determination, at least at the beginning. I don't know the answer to your question. Sorry.
Once you're up and running, can we find out what kind of offenders have been accepted into your program? It might help us have some idea in the universe of indicted crimes, what kind of candidates are accepted?
I think so. That's not going to be secret. I mean, it'll be known. There'll be public records on the dockets in the cases reflecting which defendants are being transferred out into the UACT program. We'll gather that information as well as information about, how the program seems to work, and at some point in the future, when we get there, how many people are coming through successfully, and whether they're recidivating and all of that. I do want to touch on one other thing, though, that somebody said triggered this in my mind. There will be a very clear restriction. The participants in the program, many of them will be in multi-defendant cases, and there can't be and won't be any communication between the participants in the program and the other. There already isn't going to be, but I just want to be clear about that for several reasons. One is we want to insulate the participants and from pressures and other things, and allow them an opportunity to succeed. There was another question over here, Mary.
Just following up on what Rebecca just asked, it occurs to me that there will be first batch of people selected, and then there's going to be a period of time before there may be an opening in the program or before it may expand. But if we have candidates in the meantime, whom we are representing, we think would be perfect candidates for this program, asking for delayed proceedings to enable them to seek the next available slot might also be appropriate. And I guess your answer applies to that as well. But if there's any influence that could be exerted that we're all going to need speedy trial waivers in order to make this work, I don't see how we can assess a client to get this done in 7 years.
So, let me just stress. Your clients should assume they can't get into this program. And I'm not trying to be hard about this. We changed the funnel into the program from the way it was initially designed. People aren't any longer going to be pre-selected as candidates for the program. It's open to everybody. I wanted to create a spirit of competition, not unfairly. I mean, I'm not trying to compress people. The resources necessary to run this court are significant. So we're going to start with a small population until we figure out how it works, and we all get some comfort with it. The assumption should be you can't get in. It's impossible to get in. And if you do, oh my God, you're lucky to be in. Don't waste this opportunity. I wanted to create, not to manipulate the feeling of the participants in the program, but I want them to understand it's a significant opportunity. I don't know how we'll address your situation, Mary, except there's one thing you said that I disagree with. For those of you who didn't hear, I'll be surprised if the program fills in the next few months. I mean, these folks will decide, but I think we're looking for the right people. We'll see how many applications we get and how many suitable candidates we see. I'll be surprised if we start with more than 3 or 4 to begin. And so I think we'll be adding people periodically as we go, but I could be wrong. There was a comment in the back or a question.
Yeah, I was wondering what we might tell our prospective client what they might be in for with this program. Is there an outline of, is it X number of sessions a week plus X number of counseling plus drug test? Is there someplace written something where we can give them an idea of what they're signing up for?
Yes, in the interagency agreement. And near the end of that, where we discuss the 5 phases of the program, there are detailed explanations about the number of counseling sessions, treatment, the drug testing. It'll generally be a weekly meeting. Candidly, I had hoped it would be something we could do less often. It's just going to require a lot of court time, but I've just decided we have to see them every week. We're really going to do this. They need to see the judge and the team there and everybody invested in them and keep in regular contact. So every week there'll be a reporting. Monday morning, your clients will be required to call Greg Peterson between 9 and it'll either be 10 or 11. Greg will prepare a summary report. He'll send all of us. After lunch, we'll read it. We'll meet at 3 o'clock. We'll be in court at 4 o'clock. We'll spend at least an hour together every Monday. And then that'll be on top of treatment, testing, counseling sessions, the community service requirements, and that's all set forth by phase in the program. And on top of that, we're going to require them to do some of the other thing we talked, homework stuff. Go read Chapter 9 of Parenting with Love and Logic and write a 4-page letter about it, or whatever. I mean, I don't know what that's going to look like. We've been an hour, and we're out of time. Some of you need to leave. Are there any other quick questions? No? We'll be here for a minute. To the members of the team, thank you for taking time. Thanks to all of you for being here.